Good afternoon, Chair.
Good afternoon, everyone. Once again, Advocate Noko, Advocate Chauke, Advocate Poe. Madam, you are still under oath?
Yes, Chair.
Yes. Advocate Poe.
Thank you,
May
Chair.
proceed where we interrupted you.
Chair, my colleague who's working with me on the matter has a few clarifying questions for the witness. May he have an audience? Mr. Mtsweni.
You don't have anything?
I have nothing. I have nothing.
Yes, Advocate Mtsweni.
Thank you, Chair. Madam Noko, I just want us to go through your app. We do this in order to obtain clarification on some of the aspects which came out during your evidence. And you would recall during the course of your evidence yesterday, Madam Ramakaka took you particularly raised the question of what amounts to prosecutorial decisions or acts vis-a-vis oversight. Do you recall that?
Yes, I do.
And I just want to get your comment on Advocate Chauke's conduct so that you are not criticized in future that you have not dealt with that.
Okay.
And I think the starting point would be in relation to the consent between Advocate Chauke and Smith. Do you recall that?
Yes, I do.
And you testified that in terms of section 111 of the CPA. Madam Chair, if I'm too fast, please do alert me.
I think you asked Daddy.
Yes. You testified that that kind of consent is usually done between two DPPs. Am I correct?
Yes.
And it would be one DPP consenting to have a matter that would have otherwise been prosecuted in his or her division to have that matter prosecuted in another division.
Yes.
So basically, would one classify that kind of conduct as a prosecutorial decision or as an oversight act?
That is a prosecutorial decision.
Now, we know that in this case, it was Advocate Chauke who entered into that arrangement with Advocate Smith.
Yes.
And we know that at the time, Advocate Mlochwa was the acting DPP in KZN.
Yes.
And the arrangement was that these matters, the Rustenburg case, would go and be tried in KZN.
Yes.
Not in Gauteng.
Not in Rustenburg.
Yes, and not in Gauteng as well.
Yes. Not in Gauteng.
Now, if I might ask, you testified that you had seen the authorizations granted by Advocate Mlochwa to the prosecution team.
The delegations, yes.
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 Did you see one in respect of Advocate Chauke?
No, Advocate Mlochwa was in the same level with Advocate Chauke because Advocate Mlochwa was the acting DPP. So if there were to be any authorization or delegation for Advocate Chauke to prosecute in KZN, that would have come to somebody who's superior, and that would have been the NDPP.
Yes, I'm saying from Advocate Jiba at the time.
Yes.
Did you see one?
No, I've never seen that.
And you say that the consent was a prosecutorial action, the consent between Smith and Chauke.
Section 111, yes, it's a prosecutorial decision because as a prosecutor you decide whether to take the matter that you have to another jurisdiction or to request a DPP in another jurisdiction to give you that case to deal with it. It will depend on the circumstances and facts of the case. But yes, it's a decision that a prosecutor takes.
Now, would you say that it was competent or proper for Advocate Chauke to enter into such an arrangement, notwithstanding the fact that Advocate Mlocha was the DPP of KZN?
I don't know what the arrangement was. That was before I came in.
Yes, I'm
I don't
asking you this, ma'am, so that we get all the facts
Yeah.
clear. You expressed an opinion as to whether towards the end of your engagement with the panel,
Yeah.
that there was nothing wrong with one DPP exercising some functions because there was no statute that said he can't do that.
Yes, I'm not aware of that, yes.
Yes. And if, to be fair to you, would I be correct that a prosecutor or a DPP is an organ of state?
Yes.
Would I be correct to say then he can only exercise those powers that are given to him by law?
Obviously, we are creatures of statute. We operate in terms of the law. But my point was that I have nothing that I'm aware of that legally forbids the opposite. It's silent. For example, the NPA Act is silent. It doesn't say a DPP cannot operate in another jurisdiction. So that is why I could not give my opinion whether that was wrong, illegal or not, because I'm not aware of any statute or legislation that prohibits that. For me to say any action contrary to that is a contravention of that legislation. Hence, I could not say it was illegal
Yes.
or unlawful.
I'm not sure whether you would have the bundle or I'm not sure what the witness bundles would be, but I wanted us to also examine Advocate Chauke's involvement in the matter in his own words so that I also get your comment whether was it part of oversight or was it a prosecutorial action.
Okay.
Madam Chair, I think it would be in the LO bundle. You would not have it.
She wouldn't have it. If you want to ask questions, try to make sure that you give it to her. Then she can read it.
I thought there was a witness bundle that had been on standby, Madam Chair.
You would have been, as evidence leaders, be responsible for that evidence bundle, not anybody else. But let us see if I can assist with my copy. It's LO.
LO, it's Advocate Chauke's affidavit in the Zondo Commission. It starts at LO 243. I'm skipping the zeros, Madam Chair.
You must read everything.
It's LO 00243.
LO 00
243.
243.
Unfortunately, yes, 243. I'm not sure whether it's LO1 or not because I've got it in electronic format.
It should be Advocate Mchweni. It's LO1, then 00 something.
Thank you, Madam. Thank you, Madam Chair.
Yes. We will borrow you a copy.
Okay. Thanks.
Do you have it, Advocate Noko?
Yes, I do.
Yes.
Thank you.
You, as you would see, that's the witness statement in terms of Rule 3.4. And it's deposed to by Advocate Chauke in what had become known as the State Capture Commission.
Okay.
Now, I do not think that it would be disputed. That is, in fact, his affidavit. But I just want us to zoom into what Advocate Chauke described in the Zondo Commission as being the extent of his involvement in the Keitomena prosecution. And you would find that at 265, LO1 200265.
Okay. Yes. Okay, I'm there.
Starting from paragraph 57.
Okay.
Sorry,
have
Madam
it.
Chair. I'm hoping that my learned friend will tell us at some point what is the relevance of these questions to the terms of reference.
Yes, Advocate Mchene, you are clarifying questions with the witness. You can guide all of us as to where you are getting to.
Madam Chair, is to simply, you would have recalled that Advocate Batohi testified that Advocate Chauke's involvement amounted to, not, was beyond an oversight.
Yes.
And you would have recalled, although there's no response from the President on the amendment, but you would have, in your report to the President, in your ruling, you had foreshadowed that this was not a new event. It is apparent from the, I can't recall the exact part in your ruling.
If you can speak louder,
Oh.
it will help me.
Okay. Where you, in your ruling, where you did not support the amendment, the request for an amendment, that this aspect has always been there. And it would
Which
be
aspect?
the issue of Advocate Chauke traversing, acting out of bounds, of his statutory bounds. But I will just get to the terms of reference where I can point you exactly. I'll just ask my colleague to assist me.
Yeah, it will be helpful, Counsel. You are now referring to the ruling. And you mentioned aspects that I don't remember are written in that ruling. It might have appeared in the application. So it's helpful if you can give us the context and then we can look at all the documents.
I will do so, Chair, later on.
Yes.
If that aspect might just be, if I can just have made note of what
If a need arises, we can adjourn and get the copies of the ruling. Because you are referring to it and we don't have it here. And what you are mentioning, I don't remember that part being mentioned in the ruling itself. But give us the context, and so that you can then proceed with the question. Then we can at least follow as to why you are pursuing that line of clarification.
Madam Chair, basically it also follows upon what Madam Ramakaka took up with the witnesses to whether the distinction between prosecutorial actions as well as oversight action. It simply follows upon that. But if it's regarded as not being relevant, Chair, we will know, we can abandon that.
Advocate Msheni, you asked that question earlier, and that was followed by further questions.
Yes.
You sought the response of the witness in relation to those concepts, and he answered, and then you followed that with further questions, and then Advocate Goitobi says, but where are we going to? And I'm saying to you, I'm not sure what the context of this is. You can just maybe tell us, you seek to clarify something with regard to that. And if it falls within that distinction, make it clear to us so that we can...
That is basically the concept to say whether was Advocate Chauke's conduct and oversight or not. That was just simply on that basis.
You may proceed.
Yes. Advocate Noko, at paragraph 57, I will not read that, but Advocate Chauke tells us of the circumstances which led to him being involved in the matter. In the main, that it was at the instance and at the request of Advocate Jiba, and he provides the reasons why, amongst others, he would be requested to assist and to procure prosecutors outside KZN. But what he then, at paragraph 62 on LO 00267, at paragraph 62, he outlines what his role as the team coordinator was. And in the nutshell, he says, was to deal with logistic and administrative matters of the prosecution team, ensuring the coordination between various stakeholders, and then that he was not involved. 62.3. My involvement excluded taking prosecutorial decision whether to prosecute or not. And then at 62.4, it says feedback and briefing on the team to JIBA, including submission of documents from the prosecution team to the NDPP. And then he then, moving forward, at paragraph 64, he then tells us what then started to happen. He says, on the 3rd May 2012, I attended a briefing meeting with JIBA, during which it was arranged that the prosecution team brief her on the Cato manner on 18 May 2012. And on 15 May 2012, I attended a meeting with the prosecution team for the preparation of advocate or for JIBA's briefing. Now, again, within the context, just to underline whether that conduct amounts to prosecutorial action or oversight. Well, how would you classify that?
You mean the briefing?
Yes, what he says on paragraph 64.
The briefing are actually done by DPPs in every high-profile cases.
Now, which DPP would do that?
The DPP who's in charge of the case.
In charge of the case, would it be in whose jurisdiction the prosecution will take place, or the oversight DPP?
It depends on which under which DPP that case results. So in respect of Katomena, then it was resulting under Advocate Chauke in terms of the instruction from the NDPP, acting NDPP Advocate Jiba. But then it was under jurisdiction of Advocate Simpium Loja, then myself afterwards.
Yes. So you're saying that briefing ought not to have been done by, ideally, it ought to have been done by Advocate Mlojo,
if he was overseeing the case. But if he was not overseeing the case, he could not have been expected to be the one briefing the NDPP, but the one who's overseeing it. Whether he's doing so rightly or wrongly, it's something else. But the one who's in charge of that case then, overseeing it, is the one who's supposed to brief the NDPP.
Yes. And then he goes on paragraph 68. He says, on the 24th May 2012, he attended a briefing meeting with JIBA together with the prosecution team, where Matenja did the briefing. And the briefing entailed possible charges against the suspect, the security of the prosecution team, delegations of the prosecution team, and Part 8 of the Prosecution Manual and Section 17 of the Inquest Act. Do you see that? It's on...
Yes, I saw paragraph 68, yes.
And you still maintain that the briefing still has to be done by the DPP overseeing the matter?
Advocate Msoni, the point here is that Advocate Chauke was overseeing the case.
Yep.
And he had to be the one doing the briefing. It's a different point whether he was overseeing the case rightly or wrong. But if we talk about the briefing, he's the one who's expected to do the briefing. No other DPP was overseeing the case, but he was. So he's the one who was expected to go with the prosecution team, and the prosecution team brief the NDPP in his presence. That's how it worked even with me. And in all other high-profile cases, we had a lot in KZN and we would go with the prosecution team, and the NDPP is briefed by the prosecution team, and the DPP will add here and there wherever is necessary. But the fact of the matter here is, with regards to the briefing, he was overseeing the case. No one else had to brief the NDPP except him.
Yes. And then we go on. Thank you for the clarification.
Yes.
Then at L01.
Before you proceed, Council, paragraph 68, were you focusing on the second sentence that says Matenja did the debriefing? Were you making that point?
Yes, as well as the in relation to the charges, where the possible charges are being discussed.
Where does it say that?
It said that this briefing entailed charges against the suspect, the security of the prosecution team, delegation of the prosecution teams, Part 8 of the Prosecution Manual, and Section 17 of the Inquest Act.
Yes. And with regard to the point that the briefing was done by Advocate Matenja, are you taking issues with that?
No, we're not.
Okay. Here's the next one.
Now, I just want us to jump further to paragraph 79, where he talks about having held a meeting with Mlochwa, as well as the acting DPP of KZN, as well as the acting judge president about that matter. Would you still classify his attendance of those meetings as part of the oversight duties?
The thing is, I was not in the picture yet, so I don't know what was discussed.
No, I just want to do Advocate Chauke's involvement. Would you classify it as prosecutorial, or would you still classify it as part of the oversight?
It's hard for me to say if I don't know what was being discussed, because what gets discussed determines whether it's prosecutorial or oversight. It could have been that they were discussing security of prosecutors. It could have been they were discussing who to charge with what charges. Okay. But if I don't know what they discussed, I can't answer that.
Now, let's go to paragraph 8.
Before that, 79 flows from paragraph 78. It's the 18th of June 2012. Were you the DPP at that time?
Not yet, Chair.
It was Advocate Mlochwa.
Yes, Chair.
Yes. Now, you said the question of whether it's prosecutorial or oversight depends on the discussions. Am I correct?
Partly, yes, it does.
Now, he tells us on paragraph 80 that he had a meeting with the KZN Regional Court President, Mr. Nkabinde, to discuss availability of regional court magistrates to hear the bail applications. Is that still part of oversight, or is that now prosecutorial?
This leans more on prosecutorial, because that's what prosecutors do now. You're discussing which presiding officer and all of that. Yeah, it's more prosecutorial, this one.
And would you also classify his involvement in your meeting with the judge president of KZN, where it was about arranging the judges to hear the matter? Would you also classify that as oversight or prosecutorial?
It's prosecutorial, it's the same as this one.
Yes. Okay. Now,
before you move on, Advocate Ntweni, can I, the situation that is described on paragraph 80, that on 19 June 2012, I had a meeting with the KZN Regional Court President. It differs to a certain extent with what happened when Advocate Chauke took you along to see the JP for the allocation of a judge outside the province.
Yes, ma'am.
And you've just said this situation described on paragraph 80 leans more on prosecutorial. While you say you didn't answer the same when in your situation when you went with him to see the KZN JP for the allocation, to request the allocation of a judge from outside the country. Would you care to enlighten us what is the difference?
Okay, thank you, ma'am. I remember being asked whether the request for Section 111 for the consent of Advocate Johan Smith was prosecutorial or otherwise, not about going to meet, unless I'm mistaken, but not about going to meet the JP to request for a judge out of KZN. But, okay,
It was not asked.
yes,
Then I'm asking it now.
yes.
Was it prosecutorial or oversight
This is
on the part of Advocate Chauke?
It was prosecutorial, the same with the judge president and the regional court president.
Can I proceed, Madam Jimmer? Now,
Maybe, perhaps whilst you are there, in these instances, when I look at the paragraphs that the council has referred to, 68, 79, and also in respect of that part where you indicated that Advocate Chauke approached you and you both approached the Judge President KZN.
Yes, Chair.
In those instances, the DPPs were present. For instance, as regards 79, that meeting, Advocate Mlocha was there as the DPP KZN
Acting DPP then, yes,
then.
true, Chair.
Do we know then who would have taken any decision there? Whatever decision that might have taken, the point is the DPP was there, isn't it?
Yes, the DPP was there.
In
and
your
she-
case, before you
Yes.
proceed, in your case when you acquiesced to go and see the judge president,
Yes,
it was done on the basis that it was your jurisdiction, hence you were approached to accompany Advocate Chauke. Is my understanding correct?
yes, Chair.
Which means he wouldn't go alone to see the judge president KZN without the DPP.
Yes, Chair.
In respect of paragraph 79, the paragraph where Advocate Mlocha, 79,
Yes, Chair.
the same day, that is the 18th of June 2012, where a meeting was held between Advocate Chauke and Advocate Mlocha, then ADPP KZN, to go and at the AJP of KZN. The
Yes,
point that
sure.
I'm trying to make there is that in those instances, Advocate Chauke was accompanied by either the acting DPP or the DPP.
Yes, Chair, as far as I'm aware, yes.
thank you, Madam Chair. Advocate Noko, I just want us to go then further to whether, still within the context of prosecutorial or oversight, as to whose responsibility, which DPP would be responsible, is the submission of an application for authorization in terms of Section 24 of POCA. Is that part of oversight or is it prosecutorial in nature?
That is oversight because the decisions are taken by the prosecutors. The DPP does the administrative part because what the DPP does when you send an application or recommendation to the NDPP is mainly to sign. You sign the cover memo, the prosecution memorandum is made, compiled and signed by the prosecutors. You can sign it as well, but everything is done and decided upon, even what charges to charge who are done by the prosecutors. And the NDPP will just be sort of a conduit pipe to submit those to the NDPP.
DPP.
Yes, the DPP will be that kind of conduit pipe and also approved by signing that because they are from their own jurisdiction and out of protocol as well. The DPP must be the one submitting to the NDPP, not be submitted by those below the NDPP submitting to superiors. So that is purely administrative.
I'm not sure whether she answers your question, Advocate Mchweni. Will you please repeat that question?
Thank you, Madam Chair. Madam Noko, in fact, let's put it within so that I'm clear.
Yeah.
Can you please go to, I'm not sure which part of the LO is this, but 00666.
00666.
Now you're making our life, everybody's life difficult. You can't ask a question and say, I don't know which part of the LO is. What do you expect us to
Because
do?
Madam Ramakha, if I might explain, I've got it electronically. My bundles are not subdivided as the panels bundles, so I only have it as one complete document.
I understand that, but who's the navigator here?
I'm the captain, but unfortunately, I inherited this flight because already when I came in, the bundles had already been prepared.
Advocate Mchweni,
Madam,
I think that line is stale. It's very stale. That line of saying I only came in when the plane was already in the air. You came in here before Advocate Kowe, before Advocate Skosana SC. Let us try another line, and maybe let's not even try lines.
I retract that, Madam
Yeah,
Ramakha.
thank you.
I'm told it's LO3.
I beg your pardon?
I'm told it's LO3. It's LO3.
Okay.
And I undertake that from now on, I'll familiarize myself with which LO starts where and ends where.
Thank you very much. It will be very much appreciated.
Yes, thank you. You may proceed, Counsel.
The reason well, you'd see there, Advocate Noko,
LO3 is what?
665.
661. The application, just tell us what it is, place it on record.
Yes, that's what I wanted to get there
Yes.
so that she knows.
Yes.
Advocate Noko, that is an application that was submitted to Advocate Jiba on the 15th of August 2012 for authorization in terms of Section 24 of POCA. Do you see that?
I don't see it here. I don't know where it is. They give me a laptop. I don't know where it is.
It's also not fair to the witness, Advocate Mchweni. You know very well that this witness doesn't have the bundles. You should have made proper arrangement before we reconvened,
Okay, thank you.
given the fact that this is our witness, she is our witness, you are leading her. At our instance, you should have gathered all this information beforehand.
I apologize.
And for you to ask the witness a question about something she doesn't have is very unfair.
I was under the impression that there was a witness bundle readily available.
I beg your pardon?
I was under the impression that there was a witness bundle that had been
Well, there
prepared.
can't be a witness bundle which you yourself must compile as the evidence leading team. Who would have prepared that bundle?
I take note of that. I'll make
Yes,
sure
sir.
that in future.
Yes, you cannot expect us to prepare bundles. You are an evidence leading team. You must prepare documents that you are presenting to us, and you should know them better than all of us.
I take note of that, Madam Chair. Do you have the document, Madam Noko?
Yes, I do.
That you would see it's an application for authorization in terms of Section 4224 of POCA in relation to General Boysen and others.
Yes,
Do you see that?
I see that.
Now, the question I asked you was this submission of this application, because the authorization must be granted by the national director, am I correct?
Yes.
Now, the submission of this application or the making of this application, is that an oversight or is it the prosecutorial act?
This is oversight.
Now, can we just delve into that? If you look at paragraph 2, it says, I have perused the document and recommend the application. Do you see that?
Yes.
Is that the recommendation? It's something that would I be correct that it's part of what the NDPP would consider when applying his or her mind on the application as to what is the stance by the DPP?
Yes, it is. Those
Now-
are. Oh.
Now, would you still then maintain that where you make recommendations such as this, which are going to have a bearing on the decision, that still amounts to oversight?
That is still oversight, as I'm understanding.
Yes.
You're recommending after a prosecutorial decision has been taken. You are not taking a prosecutorial decision. You are recommending as a DPP and saying NDPP for your consideration.
Okay, thank you, ma'am. Now, I just want us to also consider this document. It appears.
Pardon, Counsel. Let me understand this answer. As at August 15, 2012,
Yes, Chair.
when you wrote to Advocate Jiba applying for authorization, did the prosecutorial team, had there been a decision by the prosecutorial team as regards this matter?
I did not write this, Chair.
Oh, because I see
It-
Advocate Noko Mashilu. Who is Noko Mashilu?
It is me, Chair, but this is the document that the evidence leader from the Zondo Commission asked me about. And I said I had not seen it. I mean, that is not my signature. So I did not compile this.
Wait a minute. LO. These are legal opinions. This document otherwise would have been from ZC. If it is the Zondo Commission document. LO would have been a document coming from legal opinions. Now, I don't understand why it would have been at the Zondo Commission. I'm getting even more confused now. But are you saying this is a document that was brought to our attention
Yes, Chair.
by the evidence leader at the Zondo Commission,
Yes, Chair.
and you then said, this is, I didn't append your signature to this document or something like that, because the signature is that of Advocate Jiba here.
Advocate Chauke.
Advocate Chauke.
Yes.
And then at the bottom there is written Advocate Nomkobo Jiba.
It's written my name, Chair.
Oh, there's a,
Now you are in the second
okay, I'm on the second page. Oh yeah, I'm sorry, I beg your pardon.
Okay.
I think that's where I got confused. Yes, thank you. And then your answer is that this is not your signature.
Yes, it is not.
Thank you.
It is what I refer to in paragraph 39 and 40 of my affidavit.
May I continue, Madam Chair?
Yes, yes, sir.
In fact, this was the next question that I wanted to ask you. To say that as on the 15th of August 2012, you are already the acting DPP of KZN.
Yes, I was.
And I take it that on the 15th of August 2012, you were not indisposed, otherwise, you were not on leave or indisposed of health, whatever, for health reasons whatsoever. You were in the office.
I don't know whether I don't have my diaries. I don't have my schedule then, so I don't know what was happening really on the 15th of August 2012. It's a long time ago, so
Yes,
I don't know where I was.
I accept it.
Yeah.
But the document purports to come from your office. Do you see that?
Yes, in terms of having my letterhead and my name.
Yes.
Yes, it
And
says
at the end there, it is signed, and there's no indication whether it is PP or is it your signature or not.
I don't know, but I see this arrow. I don't know. Sometimes other people, when they PP, they put this triangle arrow. I don't know if it's a PP or not.
Now, when this application was submitted, were you briefed about the that is going to be submitted?
I don't remember being briefed, but I had a meeting with Advocate Chauke the previous week when we were going to meet the NDPP. I mean the acting judge president.
Yes.
In Durban.
Now, and you were fully cooperating with Advocate Chauke at the time, whatever his requests were.
Yes.
Now, would I be correct that if this if there was an application of this nature, and which would have been issued on your letterhead, and as emanating from your office, you would have and ought to have been aware of it, that there was going to be this application submitted in my name?
I'm not clear. on the
Sorry?
question.
You would have?
Yeah.
She would have been aware, or ought to have been aware, that there was going to be an application of this nature which was being submitted in her name.
Yeah, I guess so.
Yes. And you now told us that you saw this document for the first time during the Zondo Commission.
Yes.
And you were never told about it anywhere.
No, I wasn't.
Yes. The reason I will get to it, I just want to, because when one looks, there's a document which was an opinion by Dr. Broughton, where he, amongst others, says that apparently it was done with you, it was an arrangement between yourself and Advocate Chauke, but my junior is still finding the relevant portion of it. Now, I just want us then to move on to the memorandum that you received.
Understand the last point that you are putting to the witness, the arrangement between Dr. Broughton and the witness would have been with regard to what?
That from Dr. Broughton's opinion, it says that the submission of this application was it was in terms of an arrangement between Advocate Chauke and Advocate Noko. But they rely on an affidavit by Advocate Mosing. We're just finding the relevant part of that affidavit so that we can just get the question whether is that statement correct or not.
Yes.
Now, Advocate Noko, if we go to the document MN1.
Before, I'm sorry, before we pass that point. This point you are making with regard to the arrangement, would it appear in Dr. Broughton's memo?
Yes, it appears in Dr. Broughton's opinion. In fact, at LO 00197.
LO 3? Is it 3?
It should be 1, I think.
1.
And if
00197.
I may read,
Before you read, let's just get our volumes.
case number, paragraph 98.
Yes, paragraph.
He says at paragraph 77, he says, that's saying, however, in Advocate Mosing's affidavit in Silverton case number, it is noted as following.
Sorry, paragraph. Oh,
Paragraph 77.
Yes.
He quotes from what Advocate Mosing says in his affidavit, and at the bottom, towards the quotation, I think it's 6 or 7 lines, says, what may possibly explain the situation why the application emanated under cover of Advocate Chauke's office that it seems that Advocate Chauke and the DPP of KZN and Advocate Noko had arranged that such an arrangement in order to expedite the matter and avoid any possible delay on account of Advocate Noko being based in KZN. It seems that it was later considered prudent that Noko rather signed the document instead, but the application for centralization signed by Chauke had already been submitted by him as indicated above. And I think you would find that part, Advocate Mosing's, in his footnote, he refers to Advocate Mosing's affidavit at para 98.
Okay, should I respond?
Now, yes, now that we're there, as to whether was this an arrangement between yourself and Advocate Chauke, that he would sign documents because to avoid delays?
What you can see here, he says it seems. Like it's a.
No, I understand. I just want to get your view now. You're here. Was there such an arrangement or not?
I'm trying to answer, and I'm answering based on what Dr. Broughton is saying. He's deducing from, I don't know, from whatever he's deducing. But does he know, as a matter of fact, that that was the position? Because he says it seems as if there was an arrangement, it seems as if, to show that he is not sure about what he's saying. And he was not even part of the case.
Okay, now let me ask then,
Yeah.
was there an arrangement between yourself and Advocate Chauke that he would sign documents on your behalf?
No, I didn't have that arrangement with Advocate Chauke in that respect.
Okay. Now, I just want us to deal with your support for the decision to institute the racketeering charges.
Yeah.
And the first time...
Before you leave that point, you were just looking at footnote 70 and referred us to paragraph 98 of the affidavit to the SCC.
It's a Silverton case number.
Point with regard to that?
No, I just wanted to say that's where Dr. Broughton gets what you see there under paragraph 77. It's a quotation from that affidavit.
Yes. Yes.
So I was just trying to show where he gets that from.
Yes. Thank you.
Now, Advocate Noko, would I be correct that the first time that you got a briefing into the Cato Mena case was when you received Annexure MN1?
Yes.
And that was on the 7th of August, 2012.
2012, yes.
And that was a summary, the summary that was given to you, it was given by Advocate Chauke.
Yes.
And now, he then, at paragraph 6, gives you a number of documents. Paragraph 6 of the internal memorandum, MN1, to Advocate Noko's affidavit, the annexes to Advocate Noko's affidavit. No. Advocate Chauke's memorandum, MN1, annexure MN1, Madam Chair. I'm told it's It's MN 000. Triple 001. It's got 4 zeros. I'm not sure how to call quadruple zero. Yes, Madam Chair. It looks like it was cut.
Page
Yes.
MN.
Under paragraph 6, Madam Chair.
Of her affidavit.
I'm told it's 0003
Paragraph 6 of what?
of the memorandum from Advocate Chauke to Advocate Noko. Annexure MN1. This is the one that my colleague said it was cut during the making of copies, and she ended up, I think she ended up a hard copy.
Yes. Yes, I see that.
Madam Nuku, under paragraph 6, that's where Advocate Chauke refers to the documents that were undercover the memorandum.
Yes, the memorandum, yeah, yes.
Yes. And she tells you that what was included was the indictment and then a copy of the memorandum to the NTPP for authorization of racketeering charges together with the draft authorization certificates, as well as a request for centralization and a copy of the consent letter which he received from Advocate Smith.
Yes.
Now, if I might then ask, in your evidence that you gave earlier, and I think it's in your memorandum to Advocate Batohi and your colleagues, you go to a great length and you summarize each and every statement which informs your view why you believe that the institution of the racketeering charges was justified.
Yes.
Now, if I might ask, when did you for the first time get to come across these statements that you summarize herein?
It was when Advocate Matenjwa sent them to me.
Yes. So,
I think it was in 2014, 2015. It's in my affidavit. I'll quickly tell you. Okay, it's in page 10, paragraph 33, and annexure MN4. There's a covering letter from Advocate Matenjwa that enclosed the prosecution memorandum, the statements from witnesses. But the prosecution memorandum, I had it here from Advocate Chauke. Then in 2012, that was amended. It was different from the one I got in 2014. I think from Advocate Matenjwa.
The reason I'm asking this is because of the impression that is given by the application for authorization that was submitted under your name, where it says, I have perused the documents and recommend the application.
Okay.
It seeks to create an impression that you had applied your mind and you believe that there was a case for General Boysen and the team to answer. Do you agree with me?
Which memorandum are you talking about?
I think they took away the laptop now.
The one in 2012?
Yes.
I did not compile that. I was not in the case yet.
Yeah, but I'm just saying, I just want you to look at it, and that statement that says, because it's submitted under your name, and the impression it creates that it emanates from your office.
Yes,
But
I think in fairness, he testified that when he was contacted about this document, if it is the same document, he then answered that that was not even his signature. Am I correct?
That was not my signature.
So the fact that her name appears there and there's somebody who has signed there, and she said that this signature looks like the signature of Advocate Chauke. That's how I understood her evidence.
Okay, thank you, Madam Chair, for
And
that.
then paragraph 2 that you read, which says, I have perused the documents and recommend the application. That cannot be imputed to her because she says, I did not sign this document.
I just wanted to highlight the danger that is implied in that statement. It seeks to suggest that.
Yeah, well, it's a matter for argument.
Yeah.
The point is, the witness is testifying that it's not my signature.
Thank you, Madam Chair. May I just get one thing? Just want to get something. Now, Ms. Advocate Noko, I just want us to zoom in into your support, the basis of your support for the decisions, for the decision that you say the institution was justified. Now, and in particular, the complaint here, it's in relation, I would zoom, there were about 16 accused in this matter. Am I correct?
I don't quite remember how many there were, but there was a number of them around that, yeah.
Yes, because if you look at the way the charge is even in your memo, if you look at the number of the accused, then the highest number is 16.
16, 18.
Respect of which?
The Cato Manor charges.
The Katamana case.
Yes. Now, as a prosecutor, when you take a decision to prosecute, the primary consideration is prima facie case. Am I correct?
Yes.
That's the standard.
Correct.
In other words, is there a case for this person to answer to?
Yes.
And in light of the fact that there were 16 accused, you have to be satisfied that each one of them has a case to answer.
Yes.
Meaning that you must ask yourself, is there evidence that implicates or pinpoints this person to the commission of the offense?
Yes.
Yes. Now, let us just zoom into Major General Boyson.
Yeah.
And I can put a disclaimer right now that I do not hold a brief on behalf of Major General Boyson. I'm just simply asking this so that you get an opportunity to comment on this, so that whatever later on you're not criticized that you never dealt with these issues, and so that the inquiry can then be in a position to make an informed report.
Yeah.
Out of the 116 charges that are contained in the indictment, Major General Boyson is implicated in at least 7 of them. That would be 12, 11, 10, 9, 8, 2, and 1.
Please repeat yourself.
It's count 1,
1,
count 2, count 8, count 9, count 10, count 11, and count 12. Now, I just want us to, I don't want, given for the purpose of time, it would take us another 3 weeks for us just to analyze these charges and the evidence, and I don't want to do that. But I just want us to at least, let's look at count 1 and 2, which are the poker-related charges. The first one, it's in terms
where
of...
are they? Take us to those counts.
Just they are in the indictment, Madam Chair.
suppose your attorney is helping you there, see he's busy on the phone, that doesn't mean major. You're supposed to be helping your counsels, but you are busy on the phone there. We need your assistance as an instructing attorney.
Chair, if that will help, I know what he's talking about, and I can tell him which counts, which charges, and why those charges to shorten the whole thing.
No, it is to our benefit.
Oh,
We need to know.
you.
Go through those documents ourselves
yes, Chair.
because they are asking questions on them so that we can follow up.
Yes.
Madam Chair, I'm told it's Annexure MN004. MN4. Yes. You'd find them under paragraph 2, just at the end of paragraph 25. I'll just find it's MN008.
You have to refer us to the bolded red.
Yes. It's MN00083. Just for the record, Advocate Noko, charge 1. It says, you see under I there, it says list of proposed charges and accused involved in them. Count 1, contravention of section 21F, right, with section 22 of the prevention of the, I'm just rushing through them, but it's the enterprise management charge. And you see the accused there is accused 1, 6, and 9. And we know that General Boysen was accused number 1.
Yes.
Right? And then in count 2, it's the participation charge. I'd call it the participation charge, which Advocate Boysen is also implicated in that. And then if you turn over to is MN00085, it's murder. Count 8, it's murder. Read to section 5.1 of Act 105 of 1997.
A minute, please. You have dealt with count 1 and 2. You are now dealing with the predicate offenses.
Yes, the predicate offenses. I just wanted so that we were clear as to which charges Major General Boysen was charged in.
It is also important to highlight that count 1 and 2 fell under the PROCA racketeering charges.
Yes.
The subsequent ones
Are
fall under the predicate offenses.
Yes.
It does help.
Thank you, Madam
I'm
Chair.
sure you understand why.
I appreciate that, Madam Chair. And then under the predicate charges, Madam Noko, you'll see is implicated in count 8, which is murder, count 9, which is murder, and then unlawful possession of firearm, count 10, and then count 11, which is unlawful possession of ammunition, and then count 12, defeating or obstructing the course of justice. Unless I have missed others, those are the charges which were leveled against Major General Boysen.
Counsel? Proceed.
Now, in relation to the management charge, you would have read from the prosecution memorandum that the prosecution relied on the statement by, in fact, in relation to all to these charges, the poker charges, The prosecution relied on the statements by Colonel Aya, Mr. Dlondlo Mtiane, Bongani Mkize, I summarized them, Matonsi, and Cochrane and Danikas. Those are the documents that they relied on in order to prove the poker charges against Major General Poison,
The racketeering.
the racketeering charges.
Okay. I don't know if there are more statements because I didn't read all the statements. Those are some of those that I read, yes.
Yes.
But they also support those charges, yes.
Now, you'd agree, I just want to comment, you'd agree that the management of an enterprise basically means that one must have been overseeing this enterprise for the purpose of committing offenses. It's not just being the head of the unit. It must be aligned towards the purpose.
I beg your pardon?
Insofar as the management charge, I call it the management charge, that it is not enough for one to simply say he was in charge of the unit. His management must be channeled, must be directed, or with the purpose of that enterprise committing the offenses.
Yes, if circumstantially it's proven that that unit was sort of an enterprise based on the evidence that is here, the killing of people and all of that, then it shows it was an enterprise. And whoever is managing it is managing the enterprise because that unit is the one that has tended to be an enterprise.
Yes, but in this case, especially within SAPS, I just want to ask you this so that to get from you, did these issues did you consider them? Or do they have an impact or would they change your view on the existence of a prima facie case? The fact that within SAPS there are units and those units are under commanders.
Yes, the same applies to Ketomena at
Yes.
head command.
So
yes.
would you say that just because General Boysen was in charge of the serious and violent crimes unit, that overcomes the hurdle of management of an enterprise?
I beg your pardon, Counsel. I did not understand her testimony to say that. If you look at those paragraphs that she was reading, she then dealt with those statements about management in terms of poker, and she then further, there was evidence by these witnesses. You can go back there.
We will come there, Madam Chair. I'll come to those witnesses.
Okay.
Yes. Now, in relation...
But what I would like you to do, don't put it as if the reliance was only on the fact that he was a manager. Maybe you can couple it together so that it is conclusive. Then we know what he's answering.
Yes. Thank you, Madam Chair. Now, if one reads the statement by Colonel Ayer, all that Colonel, if you understand the theme, Colonel Ayer seems to complain about being overthrown by General Boysen, who basically he complains about being undermined by General Boysen because he says, in fact, this unit ought to have resorted under him, but they disregarded him and then they were reported directly to Boysen. Did you understand the statement to mean that?
Yes, he mentions that, yes.
Yes. And then we then come to the statement of Danikas.
Okay.
Danikas refers to a number of incidents that happened at least pre.
Counsel, I'm sorry to interrupt you. The previous statement as regards is that Colonel Ayer, you are making it to buttress the point that actually the person who ought to have been a manager was him and not Boysen.
Yes. And that's the essence of the complaint in the statement. And I just want, basically, in fact, you're reminding me, just that, does it, in her view, but support the contention that he was a manager or not of an enterprise?
I'm sorry, Madam Chair. Colonel Aya gave 3 statements. They say many things. The witness is not being correctly put to say that all that he complains about is X. That amounts to misleading a witness. If my learned friend wishes to put the statements of Colonel Aya, they must put all of the 3 statements and go through them.
Thank you, Madam Chair. Just for Advocate Muretobe's comfort, I did not intend misleading the question. To the extent that it came across as if I'm seeking to mislead, that was never the intention.
Yes, ma'am.
I just want to comment that I think it is common cause that whenever there's reference to documents, those documents must be available. Okay, can we just subscribe to that and do that, please? Otherwise, there'll be this toing and froing. If you want to make reference to the statement, you make reference to the statement and say the essence of this paragraph in particular, or the essence of the entire statement. It will help us. All of us will be on the same page through and through. Thank you. Thank you, Chair.
Thank you, Madam Ramachar.
Now, you drew our attention to the statement by Colonel Aya, where he complained, apparently, that he was overlooked. I'm not quoting him verbatim, but instead of reporting to him, they reported to Major General Boyson. Is that correct?
Yes, that's the first statement. I'm just trying to get to.
This is his saying so.
Yes, I'll just. That's the theme of the statement.
Yes.
I'll just try and get the next witness. They are in fact in Advocate Batohi's.
And also, as you search, if you can tell us, what do you seek to establish by this question?
We just want to point out these aspects to her as to whether, in light of those, does she still maintain her view that the prosecution was justified? That's just we just want to clarify whether did these aspects cross her mind? Did she pay attention to them? That's all that we're seeking to do, Madam Chair.
By virtue only of a statement by a witness who says, I was actually the boss, but I was overlooked, and instead of them reporting to me, they reported it to Major General Boyson. Could it ever mean that the prosecution was then wrong or improper, just based on that statement alone?
No, Madam Chair. Well, I think, Madam Chair, in view of that, then I think that just...
Yes, but I'm trying to understand. We know on the evidence that we have, at least of several witnesses, is that which up to now has not been refuted, that seemingly General Boyson's played a critical part, be it managerial or otherwise. If it is managerial, that still has to be established under the POCA provisions, Section 2, Count 1 and 2. That is where this feature of him having played a managerial aspect may kick in when you look at the concept enterprise. Are you taking issues with those statements that are made by witnesses that advocate, I beg your pardon, Major General Boyson's played those parts or those roles?
No, Madam Chair, like I tell you, I don't hold a brief for Major General Boyson's for him to come and dispute that.
Yes, would you please repeat that statement in regard to, as regards Colonel Aya then?
Because I'm trying to understand the point.
And
that
I
you are
think,
making
well,
there.
what we just wanted to just to say whether the theme of the statements would they change them, that in light of the themes of the statements, does she still maintain a view? But in light of the fact that those statements have not been disputed, and will not take it further, Madam Chair. And I think on that note, that brings to an end my clarification. Those are the issues that I just wanted clarity on.
In any case, your witness, Colonel Ayer, apparently you're going to call him. Is that Colonel Ayer?
No, it's poison, I think that's going to be called.
We'll look into that later, but it appears that this witness, if my understanding is correct, on the list of witnesses, because he made several statements, this,
Yes.
This officer. I'm not sure whether you came at the time when you had dealt with the NJs. Those statements, NJ3, NJ4, NJ2, they are attached to Advocate Batohi's affidavit, supplementary affidavit.
Yes, I'm aware of that.
If you can look at the supplementary affidavit and look at those annexes, you'll find those statements there.
Now, I've taken note of that, Madam Chair, but in
Yes.
view of the fact that of the regard that these statements have not been refuted, I don't think that there's we've got any reason to take them up with the witness.
Yes, I'm
And
not
that-
sure how the witness can help in that regard because she's not a deponent of those
Yes.
statements.
So then I think that would bring that brings about the end of my clarification, Madam Chair.
Chair, through you, much as Advocate Msweni would like to part with us on this point, it does help just to understand even what the thinking and the understanding of the evidence team is about these statements. It is correct that the statement, we have more than one statement of a general or Mr. Ayer. Is it correct?
Yes, Madam.
Now, when you say that the essence of his statement,
That was the first statement, Madam.
yes, Ayer, you're talking about Ayer. Oh, the essence of the first statement,
Yes.
not the essence of
The
his
entire
statements.
statement. No.
Or now I understand. Maybe
Yes.
I was not listening properly.
Yes.
That's fine. There's no need to ask you further questions.
Thank you. I think, Chair, thank you for the
Thank you.
indulgence. I've got no further questions.
As regards the counts, I want to clear my mind, particularly in relation to the racketeering charges, because most of those questions you raised seem to fall under the poker racketeering, counts 1 and 2.
Yes.
That might take us to the argument point on the law. So I was just wondering why you go that route, because much could be said about those issues. But if a need arises before the witness retires, I'm sure you can come back and re-examine
Thank you, Madam Chair.
on these very issues, because you referred us to documents. I don't think you looked at some of them. In re-examination, if some of the matters might arise in cross-examination, you will re-examine on them.
Thank you, Madam Chair.
Anything else from the evidence leading team?
Chair, safe to pass the message that our leader, Advocate Kosana, has a pupil lecture to give at 4.
I beg your pardon?
Advocate Kosana had requested to be excused as he needs to give a lecture to the pupils at 4. I'm not sure whether we'll still continue beyond this or not, but he had asked that he be excused so that he can attend to provide the lecture. But Advocate Noko and I are more than capable of
I
holding
thought
the
this
fort.
is your gentlemen. For anybody to leave this inquiry to go and lecture students, this is very important. Advocate Skosana, with due respect to you.
Yes, so sorry, Madam Chair. I had been asked by our bar to give the lecture, but actually it's not actually 4 o'clock, it's about 5, Madam Chair. I had put it after hours, assuming that we'd have adjourned around 4:30 or so, then I could rush down to chambers. But I didn't anticipate that would go beyond. And I see now that today it might be that case. I just wanted to ask for that excuse. Yes.
You'll remember in chambers I mentioned that we may have to run late, until late, even tomorrow, because we have lost so much time. And I think all of us must prioritize the matters of this inquiry. I was actually, but I'll ask you when we finish with my colleagues as to whether Advocate Batohi starts or starts tomorrow. Then I will ask you something. Let me just be clear. So you are done with your clarifying questions?
Yes, Madam Chair.
Thank you, Council. It's 4 o'clock, Advocate Batohi. If we can make progress maybe with the preliminaries, if you
yes.
like.
Yes, I'm happy to start, Madam Chair.
Okay. We are agreed that time is of essence, and we will use whatever time, even if it is an hour, to make a start, because this witness is available only until tomorrow. She's practicing, and she has left her practice to come and assist this inquiry. She's not been paid for coming here to assist this inquiry, so we should utilize this time to finish her evidence and to excuse her. Then we can deal with other matters. I'm told that tomorrow afternoon you have to fly back or drive elsewhere, Noko.
Yes, Chair, but just to clarify, I'm not practicing. I'm busy with other things.
Oh,
Yes.
you are busy with some. You are
With
no
other
longer
things. I'm not
under the
practicing.
NPA, though.
Yes, I'm not, but I'm not practicing yet. Yeah.
Well,
But
that's,
I'm busy with
that's
my
that's
things.
business.
Yes, it is. I'm busy with other things.
Yes. Well, I think we just appreciate the fact that you made time to come
Chair.
to testify.
Yes, Chair.
And you have indicated that you'll be available for the 3 days,
Yes, Chair.
yesterday, today, and tomorrow.
Yes, Chair.
Therefore, let us use whatever time that we have. And Advocate Skosana, I plead with you that you request the bar that you are on a brief here and this matter is running, because it will not be fair to leave your juniors on their own, and Advocate Mutlamonyani is not here, and now you are leaving 2 SCs, leaving the juniors. I think it is important that one of the leaders must be here, at least as far as I'm concerned. So I request that if we go until, say, about 5:30, just explain to them that you may be late, because I consider that this is very important to finalize. The lecturing can be postponed to another day, and your attorney is sitting right next to you. I'm sure he shares my sentiments. That is very much. You are an instructing attorney here.
Yes, Chair.
You agree?
To the release. No, I was not approached, Chair, so
You are taken by surprise.
Yes, sir.
I can't. Counsel, and you cannot take your attorney by surprise. He's the man who's paying your fees, and please involve him. And I'm sure all of us understand why we have to prioritize this matter to whatever cost and to finish it on time. I'm going to request that we take a comfort break, those who want to go to the clinic, and we come back and start with cross-examination.
How long is the comfort break, Madam Chair?
Let's take 10 minutes. 10 minutes, we can stretch our feet, our legs, and come back. Thank you. We'll adjourn for 10 minutes, let's say until 5 past 4. We adjourn.